Hello students, good morning. I hope you all are fine and doing well. So student, yesterday we have started the chapter police and court. So today we will continue this chapter. And yesterday we have discussed about the police hierarchy at district level, then guideline of the police, okay, during the investigation. Then today we will start with the first information report. FIR means first information report. Yes, but a first information report. What is the first information report? In first information report recorded by the police officer, and it is lodged by the aggrieved party and during the occurrence of the crime, and on the basis of the FIR, police begin investigation. Where we can file the FIR? Yes, FIR can be filed at police station of the concerned area under the jurisdiction of offence has occurred. So FIR must be filed by the officer in charge or assistant sub-inspector. So we can file the FIR concerned police station, and FIR must be filed by the inspector of the police station or assistant sub-inspector of the police station. Then how to file an FIR? How to file an FIR? Yes, a proper procedure has to be followed to be file FIR. First is the informant. Informant, the person means a person who is giving the information. Informant meet the officer in charge of the police station and read the whole incident or read the whole crime which occurred. The officer write down the complaint and signed by the informant. Then means FIR must be filled by the informant also. So the information is given, then it's entered in the book kept by the officer. A copy of FIR given to the informant, and in FIR contain following details. In FIR, the information must be there, such as the date and hour when the crime was committed and reported, and the place where it occurred, name and address of the complainant, and the name and address of the suspect, description of the crime, and in case of theft, detail of property stolen. Then section of the laws which applies to the offence. What if officer in charge refuse to file the FIR? Yes, what we can do if officer in charge refuse to file the FIR, then we can write down the FIR and we can post to the superintendent of the police, right? If superintendent of police is convinced, then he or she order to the police for investigation, right? So next is the directive of Supreme Court on FIR. What are the directives given by the Supreme Court and FIR? So first thing is that FIR must be filed as soon as information about an offence is received. Second is, before beginning the investigation, the concerned police officer must make an interference from the fact mentioned in FIR that offence has been committed. If FIR registered at the police station, even the scene of the crime is not fall under its territorial jurisdiction, then FIR should be forwarded to the concerned police station as soon as possible. Then process of criminal justice. Yes, what is the process of the criminal justice? As we know that that court cannot act on its own, right? So if only victim make appeal before the court, then only court can act. The procedure of the civil cases and criminal cases are little different, as I told in during the term 1. Then, for example, matter of family and property dispute involved a party approach the court, then court settle the matter. But there is a different procedure followed in criminal cases. So, aggrieved file an FIR. Then on the FIR is filed, once FIR filed, the police begin investigation, crime, examining the crime scene, question the witness, record the statement, conduct the search, and collect the evidence. So it also interrogate the suspect and, if needed, arrest the suspect. After the investigation, police find the sufficient evidence against the accused, then it arrest him, then police file the charge sheet in the magistrate court. Right. So after the charge sheet has been filed, the trial begin. Trial begin means in court case begin. Then accused is given opportunity to defend himself. So he can hire a lawyer. So the lawyer is known as a defense lawyer. And the lawyer who present the complainant case is known as public prosecutor, which I told yesterday. In India, person is considered innocent until proven guilty in a court. Yes, we can call person guilty only when in court it is proven that that person is a guilty. Okay, we can consider only then, not before. So the court find accused guilty, the court award the punishment. The quantum of the punishment depend upon the nature and we can say nature and the crime committed, right? So court award the punishment on the basis of the crime. So role of the defense lawyer and role of the public prosecutor. Yes, role as we know that defense lawyer present the case on the behalf of the accused, and defense lawyer try to prove that accused is not guilty, right? And accused is given full opportunity to defend himself, right? And after the judge pass the impartial judgment only after hearing the both side of the case. Now, role of prosecutor. The role of a public prosecutor present the case, complaint, and it pointed by the state. First of all, a public prosecutor is appointed by the state, and public prosecutor present the case of a complainant. So, the role of a prosecutor is that he has to prove that accused is a guilty, right? So, I hope you understand this concept. Thank you. Have a nice day.